All right, as I get some legal analysis then on the matter, when I joined via Zoom by legal analyst Reitumetsi Benedict Phiri to give some legal insight on these current developments. A very good afternoon to you, sir. It's always a pleasure to have you on the show.
Good afternoon, and thank you for having me.
You're most welcome. Let's talk about this recommendation that was made by the Medical Parole Board. This is really being used as a sort of stick to beat the release of the former president on medical parole. I mean, at the end of the day, it is a recommendation, and I think this case was made by the former president's legal team, that a recommendation cannot be then binding. Why are we being forced to see this as a binding sort of decision?
Well, I think if you look at the architecture of the Correctional Services Act, it suggests really that the first starting block before the commissioner can grant medical parole is to get a positive recommendation from the Medical Parole Advisory Board. So that's effectively what, when you read the act, it suggests. And then after that, then he determines a number of other factors, including whether the inmate has a propensity to reoffend and, the arrangements that are made for him. And I think that's an important way that the act has been framed. If you look at the history of this particular piece of legislation and why it came into being in 2012. In 2012, following, the much publicized Shabir Sheikh medical parole, the act was tightened up to ensure greater fairness and transparency and an independent objective assessment of medical parole that didn't sit with the inmate's doctor at that particular point in time. So if you adopt the interpretation that the commissioner and Mr. Zuma to some extent would like you to adopt, then you basically stuck back in 2012, which really wasn't the object of this act. At least that's what I understand that, the respondents will argue as they're currently arguing right now.
One of the justices, you're talking about the issue of reoffending. One of the justices did raise the question to Mpatlele SC about, whether or not there's a likelihood that the former president would reoffend. And I heard Mpatlele talking and raising the issue of his senior age. I think he said the former president is 79 years old. In your view, is that relevant to this particular case? Because, I mean, even if he is 79, he can reoffend in this particular case when we're talking about whether or not, he would appear before a court and refuse to, for contempt of court. He could reoffend on that case, couldn't he? I mean, was the age issue necessarily relevant in this particular case?
I think definitely to the question of reoffending, the age issue is irrelevant in the context of a constitutional court order that, even not so long ago, in the context of this particular matter, the former president said, he's the first prisoner of the Constitutional Court, etc. So it wasn't relevant in this particular context. And I don't think it's actually relevant to the question as to whether, from an objective perspective, Mr. Zuma actually did suffer from a terminal condition, or his condition was such a state that he couldn't look after his daily affairs. And really, that's the crux of this point or this matter right now, as to whether there was objectively those factors, and if there were, was the Medical Parole Advisory Board the last say on whether those factors were there or not, or was Mr. Arthur Fraser then capable of determining that for himself?
Yeah. So the issue or concern at the end of the day then is that the medical recommendation concluded overwhelmingly that the former president is not physically incapacitated. What must then be proved by the legal team is that he actually is or was incapacitated to conclude his sentence. Do you believe they're on their way to doing that and to indeed proving that this is someone that is incapacitated indeed to fulfill his sentence?
Yeah, I think Mr. Zuma's team and the Correctional Services team has tried very hard to rely on the application for medical parole that was completed by Dr. Mafe. The question they referred to there that he responded yes to was whether Mr. Zuma suffered from a terminal illness or condition or a chronic condition. And the answer was yes. And you would have heard one of the justices saying, well, what was it yes to? Was it yes to the chronic condition, or was it yes to the terminal illness? Because we're none the wiser. And in fact, if you construct the entirety of that application, a different answer can actually be seen. So, Mr. Zuma and the Correctional Services Department really trying to stretch Dr. Mafe's application to say that, well, at the very least, when Arthur Fraser determined, when he got all the medical reports as well as the decision of the Medical Parole Advisory Board, he had a report that said there was a terminal condition, notwithstanding what the Medical Parole Advisory Board said. So that's important, of course, because...
Sorry, continue. You may continue.
Yeah, so that's important because a big piece of the argument is that in terms of Section 75(7), Arthur Fraser does have a general discretion to grant medical parole to offenders that serve less than 24 months. So if you can give him a basis upon which he can grant medical parole, then he fits then within Section 75(7) and would have been entitled to give Mr. Zuma this medical parole. But again, I think that's a tall argument, and I think you should see the respondents make quite easy way of that as they go through their arguments and submissions this afternoon.
All right, so I'm obviously looking towards the end before we get there, but what happens should the SCA then not overturn that previous decision? I mean, a lot of people are obviously asking the question, does that then mean that the former president then goes back behind bars? What is the process or procedure thereafter? And of course, there were questions that were raised about, the fact that there was never even a trial about it in the first place. So what then happens from that point onwards, should it happen in this way, that the SCA doesn't indeed overturn that particular decision?
And for me, that for me is really the most critical part of this particular matter. I don't think the SCA will be able to find that Arthur Fraser's decision was lawful. And then the question will be, does the former president then go back to jail? And if he does, how long does he go back for? And there, the real consideration will be what is fair to Mr. Zuma. And you have to assume, obviously, as we've heard, that he didn't participate in this and really had no wrongdoing in this particular effect. But at the same time, what has to be fashioned has to effectively vindicate the constitutional court's order that put Mr. Zuma in jail to begin with. So I think, and you'll see there's a lot of debate around, does this decision then go back to the commissioner? So in other words, you send Mr. Zuma back to jail and then ask the commissioner to make a fresh decision. The counter arguments are, well, you can't. If you take the position that the Medical Parole Advisory Board is the final decision maker, then you're stuck with actually sending him back to prison. And then the question is, how long for? And I think that is really going to be an interesting debate as we listen out, later as we hear the arguments and what will then come in reply from the commissioner as well as Jacob Zuma's team.
All right, Reitumetsi Phiri, always a pleasure. Thank you so much for giving us your time and giving us your analysis as always.
Thank you.